Hello students, this is Oshijan again with you to discuss the scope and areas of forensic psychology, the relationship of psychology and law, and the ethical issues to be observed in conducting research, fieldwork and legal activities in the area. The discussion will also throw light on the need and importance of studying forensic psychology. This episode will end with the major conclusions of the various issues discussed in the previous and the present episodes, scripted by Professor Gyanesh Kumar Tiwari, Assistant Professor, Department of Psychology, School of Humanities and Social Sciences, Dr. Hari Singh Gaur University, Sagar, Madhya Pradesh, India. The presentation in this episode will follow the following order. Module 1, Scope and Areas of Forensic Psychology. Module 2, Psychology and Law. Module 3, Ethical Issues in Forensic Psychology. Module 4, Importance of Forensic Psychology. And Module 5, Conclusions. Now, going towards Module 1, Scope and Areas of Forensic Psychology. We can understand the nature and meaning of forensic psychology by understanding the role of forensic psychology in greater details. A forensic psychologist is consistently interested in the issues that arise out with the interaction of psychology and the law. The major role of forensic psychologists is to play the role of clinician, researcher and legal expert. While playing the role of a clinician, the experts of this field are concerned with mental health issues related to the legal system, comprising both research and practice in a variety of settings such as schools, prisons and hospitals. Otto and Heilbrunn, 2002. They are also concerned with the assessment and treatment of people with mental disorders. As a researcher, forensic psychologists are primarily associated with the validation of an assessment tool standardized to predict the risk of an offender being violent, Krop and Hart, 2000. While practicing in the field, the forensic psychologists involve themselves in the assessment of an offender to make the judgment about the risks of releasing an offender. Other major roles of forensic psychologists as clinician are: first, to study the divorce and child custody mediation. Second, to determine the insanity and fitness of the offenders to stand trial. Third, to provide their expertise on testimony in court on questions of a psychological nature. Fourth, to carry out personal selection for legal professionals. Fifth, to conduct critical incident stress debriefings with police officers. Sixth, to design and conduct treatment programs for the offenders. As a researcher, forensic psychologists carry out experiments and scientific researches with other methods along with practicing as clinicians. As a researcher, they do the following duties. Firstly, to examine the efficacy of risk assessment strategies. Secondly, to study the factors influencing decisions of judges. Thirdly, to develop and test efficient and reliable methods of lineups of eyewitnesses. Fourthly, to evaluate the treatment programs of the offenders and victims. Fifthly, to study the effects of style of interrogation and questioning on the accuracy of recall of the witnessed details. Sixth, to examine the effect of personality, arousal and other variables on accuracy of the eyewitness memory. Seventh, to help the legal personnel to manage their job stress in their third role of legal scholar is less common than the two mentioned above. According to Brigham 1999, in the role of legal scholar, they carry out the following functions. First, to analyze the mental health, law and psychologically oriented legal movements. 2. To carry out analysis of policy and legislative consultations. 3. To train and teach the legal officers working in the field. 4. To identify new issues of importance to legal processes arising out of new technological and social developments. Now, subdisciplines of forensic psychology. There are many subspecialties which work in close association with forensic psychology. One is forensic psychiatry. Similar to the clinical forensic psychologists, the forensic psychiatrists get training to carry out assessment, treatment and research of the individuals facing mental health problems who involve in legal proceedings, and both the experts attempt to understand the origins of violent behaviors. 1. Unlike clinical forensic psychologists, forensic psychiatrists have their background in medical field and they adhere to and practice medical model in the diagnosis, treatment and prevention of the mental health problems and give less emphasis on psychological and environmental genesis. In addition to forensic psychiatry, there are many other related disciplines which work in close connection to forensic psychology. Anderson 2012. 2. One such is forensic anthropology, which seeks to examine the residues of defunct individuals to ascertain the probable reasons of death and to establish facts associated with their identity, such as their gender, age, appearance, and so forth. 3. The forensic art works in association with other forensic scientists to apply art to aid in identification, apprehension, and conviction of offenders by preparing sketches of suspects, reconstructing faces of deceased victims, or determining how missing persons might look as they grow older. 4. Forensic entomology is concerned with the way insects can assist with criminal investigations and help to determine the time of death based on the analysis of presence and development of various insects on a decaying body and remains of body. 5. Forensic odontology is a subspecialty which studies the dental aspects of criminal activity and helps the investigating agencies to identifying the dead individuals by examining the dental records or bite marks observed on the affected individuals. 6. Forensic pathology scrutinizes the leftovers of dead bodies in an attempt to determine the time and cause of death through physical autopsy. 7. Forensic podiatry applies its knowledge to specify the role of feet and lower limbs functions in police investigations and court proceedings. It also analyzes advice provided by footprints and footwear of the criminals found at crime scenes to help know the potential on the basis of the degree of match. They also help to determine gait patterns of the particular suspect recorded by security cameras. Module 2. Psychology and Law. In the last episode, we discussed the meaning, definition, history and scope of forensic psychology in detail. The discussion made it clear that forensic psychology is interdisciplinary in nature and it creates an interesting field of inquiry, offering a diversity of the roles of practicing individuals. According to Henne, 1980, the relationship of psychology and law can be explained in three ways. It can be put as relationship of psychology and the law, psychology in the law, and psychology of the law. Firstly, the relationship of psychology and the law denotes the field of role of legal scholar, and in this sense, psychology is viewed as a separate discipline examining and analyzing various components of the law from a psychological perspective. Bartle and Bartle, 1994. In this role, the psychologists attempt to answer the questions communicable to the legal community. Secondly, the psychology in the law posits that Wealth of psychological knowledge of its different areas can be applied by psychologists, police officers, lawyers, and judges. Thus, psychology in the law involves the use of psychological knowledge in the legal system and may have different forms. Haney, 1980. In this form of relationship of psychology and law paves the psychologists to provide their expertise to the legal system to unravel issues of testimony in a particular case. Thus, psychology in the law emphasizes the use of psychological knowledge in legal settings. Thirdly and lastly, psychology of the law focuses application of psychology to study the law itself. Haney, 1980. In this form, it assesses the role of legal officers, legal system, and legal procedure to understand the effectiveness of the existing practices to reduce the crimes in the society. Although these issues do not constitute the core issues of forensic psychology, but recent years have witnessed a growing interest in this direction. The set of questions it poses requires the cultivation of the skills of the interdisciplinary specialities, as it may sometimes advocate for system change which requires knowledge of criminology, sociology, and law. The role of police in reducing the domestic disputes, the role of law in reducing the amount of crime, and reasons behind the use of discretionary power in the criminal justice system is some of the questions which arise out in this form of relationships between psychology and law. Now, fields of forensic psychology. The field of forensic psychology has gained its popularity in very short span of time and has now become a recognized and legitimate field of study. Thus, forensic psychology can be said to have established itself as a discipline. According to Schuller and Ogloff, 2001, have put forth 5 reasons in favor of this argument. First, a growing number of high-quality textbooks have been published that provide the opportunity to teach students about forensic psychology. Second, a large number of academic journals are now dedicated to various aspects of the field, and more mainstream psychology journals are beginning to publish research from the forensic domain at a regular rate. Third, a number of professional associations have now been developed to represent the interests of forensic psychologists and to promote research and practice in the area. Fourth, new training opportunities in forensic psychology at both the undergraduate and graduate level are being established in North America, and existing training opportunities are being improved. Fifth, finally, the American Psychological Association formally recognized forensic psychology as a specialty discipline in 2001. Module 3. Ethical issues in forensic psychology. Ethical issues in forensic practice have come into focus within the past years with the revelation that several psychologists were involved in the torture of detainees, misuse of psychological tests, and interventions in the service of torturing inmates. Kuchar and Keith Spegel identify 9 core ethical principles for forensic psychologists. First, doing no harm. Second, respecting autonomy. Third, benefiting others. Fourth, being just. Fifth, being faithful. Sixth, according dignity. Seventh, treating others with caring and compassion. Eighth, pursuing excellence. Ninth, accepting accountability. American Psychological Association APA guidelines. The fields of forensic psychology and its practice have witnessed drastic change in the last 50 years. APA gave recognition forensic psychology as a specialty in 2001. The practice of forensic psychology differs in important ways from other disciplines. So, specialty guidelines for forensic psychologists were developed and published in 1991. Committee on Ethical Guidelines for Forensic Psychologists 1991 with revision in 2001. The goals of these guidelines for forensic psychology are: first, to improve the quality of forensic psychological services. Second, to enhance the practice and facilitate the systematic development of forensic psychology. Third, to encourage a high level of quality in professional practice. Fourth, to encourage forensic practitioners to acknowledge and respect the rights of others. Fifth, these guidelines are intended for use by psychologists when engaged in practice of forensic psychology. Now, major ethical guidelines. Major ethical guidelines as proposed by APA are as follows. First, responsibilities. Forensic practitioners strive for accuracy, honesty and truthfulness in the science, teaching and practice of forensic psychology, and they strive to resist partisan pressures to provide services in any ways that might tend to be misleading or inaccurate. Second, competence guideline. While practicing, forensic psychologists may consider the relative complexity and specialized nature of the service, relevant training and experience, the preparation and study they are able to devote to the matter, and the opportunity for consultation with a professional of established competence in the subject matter in question. 3. Diligence. Forensic practitioners explicitly go for agreements that comprise the scope of, time frame of and compensation for their services. 4. Relationships. In forensic practice, practitioner-client relationship is important, which is determined by the information exchange between the potential client and forensic practitioner prior. In forensic practitioners, that relationships are established with those who retain their services and those with whom they interact. 5. Fees. Forensic practitioners may consider factors such as their experience, the time and labor, the novelty and difficulty of the questions, the skill required to perform the service, the fee customarily charged for similar forensic services, etc. 6th, informed consent. The methods and procedures of forensic practitioners are complex and may not be accurately anticipated by the recipients of forensic services. Forensic practitioners strive to inform services recipients about the nature and parameters of the services. 7. Conflicts in practice. In forensic psychology practice, the relevant parties or agencies must be known to the conflicts, responsibilities and demands to resolve it. 8th, privacy, confidentiality and privilege. It is also important that forensic practitioners recognize their ethical obligations to maintain the confidentiality of information relating to a client or party. 9th, methods and procedures. Use of appropriate methods by forensic practitioners in the face of performing examinations, treatment, consultation, educational activities or scholarly investigations is essential. 10th, assessment. Forensic practitioners must provide information relevant to the psycho-legal issue, which generally involves functional abilities, capabilities, knowledge and beliefs of the examinees. 11th, professional and other public communications. To promote understanding and avoid deception, the practitioners may communicate their services, public statements, professional reports and testimony in a very objective manner. Now, Module 4, talking about importance of forensic psychology. The forensic psychology is a scientific discipline with applied focus which seeks to understand human behaviors in justice system. It aims to uncover fundamental legal principles with the emphasis on expert witness testimony, competence to stand trial, child custody and visitation, or workplace discrimination. It also helps to testify in court as an expert witness and reshaping psychological findings into the legal language of the courtroom. It makes an effort to develop an understanding into the nature, philosophy, rules and standards of the judicial system. It is a growing and accommodating branch of inquiry which accepts facts gathered in other scientific branches. In short, its importance in studying human behaviors in legal settings lies in the roles played by the forensic psychologist in the form of academic researcher, consultant to law enforcement, correctional psychologist, evaluator, expert witness, treatment provider and trial consultant. Lastly, Module 5, that is conclusions. Forensic psychology is an interdisciplinary branch of inquiry which facilitates the interaction of the practice or study of psychology and the law. According to American Psychological Association 2017, forensic psychology is a specialty in professional psychology characterized by activities primarily intended to provide professional psychological expertise within the judicial and legal systems. Forensic psychology has a relatively short history which can be dated back to the late 19th century. The field began with the study of eyewitness testimony and suggestibility. North America and Europe can be contributed to take initiatives to start studying scientifically some issues in the late 19th century which can be termed as the beginning of forensic psychology. Cattell conducted some experiments on the psychology of testimony. Researches by Bennett and Stern on testimony of children were the forerunner of reality experiment that is now used by eyewitness researchers to study eyewitness memory. Legal classes in Europe and North America initially disapproved the role of psychologists as the expert witness and finally led to recognize their role. The history of forensic psychology is marked by many important milestones, both in the research laboratory and in courtroom. Hugo Munsterberg played a scientific role in establishing the field of forensic psychology in North America. Currently, forensic psychology is viewed as a distinct and specialized discipline. While practicing in the field, the forensic psychologists involve themselves in the assessment of an offender to make the judgment about the risks of releasing an offender. The major roles of forensic psychologists are clinical, researcher and legal scholar. There are many subspecialties which work in close association with forensic psychology such as clinical forensic psychology, forensic psychiatry, forensic anthropology, forensic art, forensic entomology, forensic odontology, forensic pathology and forensic podiatry. The relationship of psychology and law is in three ways: relationship of psychology and the law, psychology in the law and psychology of the law. Ethical issues in forensic practice have come into focus within the past years with the revelation that several psychologists were involved in the torture of detainees, misuse of psychological tests and interventions in the service of torturing inmates. According to American Psychological Association, forensic psychology is a specialty which requires ethical standards to be observed by its practitioners to improve the quality of forensic psychological services. Major ethical guidelines as proposed by APA are responsibilities, competence guideline, vigilance, relationships, fees, informed consent, conflicts in practice, privacy, confidentiality and privilege, methods and procedures, assessment and professional and other public communications. To promote understanding and avoid deception, the practitioners may communicate their services, public statements, professional reports and testimony in a very objective manner. At a concluding note, summarily we can say the clinician, researcher and legal expert are the major roles of forensic psychologists in various settings with legal purposes. Psychology can relate itself to the field of law in three ways. The phrase psychology and the law refer to the use of psychology to study the operation of legal system. Psychology in the law refers to the use of psychology within the legal system as it operates. Psychology of the law refers to the use of psychology to study the legal system itself. Forensic psychology is a specialty which requires ethical standards to be observed by its practitioners to improve the quality, reliability and validity of forensic psychological services. With all these informations here, we come to the end of today's lecture. Now it's the time to you to self-study. This is Oshi Jain signing off. If you want to learn more and enhance your knowledge, you can log on to our website for MCQs, quizzes, LORs, www.cec.nic.in. Hope you have understood well. Till then, keep studying and goodbye.